Well, I think that question most often comes up because people are thinking that if I get married in my home country and I somehow tell the consulate officer through the visa application process that I've never been to the United States, that I'm not going to have to apply for one of the waivers because I have the 3 or 10-year bar. And that's just ridiculous. We would never recommend anybody try to obtain an immigration benefit by means of fraud. There is almost always going to be some indication of proof that the person was here before, or the simple fact, how did they meet? How did you suddenly meet this U.S. citizen and decide to get married in your home country if you had never been here? So I think sometimes people are misadvised in trying to do that because they don't want to have to be subject to the 3 or 10-year bar, so they try to claim that they met in their home country and they never were in the United States. That's ridiculous.
Well, it doesn't matter where you get married. If you marry a U.S. citizen or a permanent resident, that establishes a legal marital relationship as long as it is in conformity with the law of wherever it occurs. However, I think what many people are wondering is it possible to just get married in the home country and omit the fact that they were previously in the U.S.? And no, that doesn't work. You know, we always tell people that any misrepresentation or fraud committed in trying to apply for an immigration benefit is certainly a ground of inadmissibility. It's a ground of being denied that requested visa or status. And if it's related to a marital relationship, if it's a fraudulent marriage or not a bona fide relationship, then that's a ground for permanent ineligibility for immigration status. So if somebody is in the U.S. and they're in the U.S. illegally, leaving and returning to the home country to marry a U.S. citizen is not going to help the situation. It's going to require, I assume, some sort of misrepresentation, which is never a good path to start down.